Greetings, my name is Yitong, and this is our Family Law Group presentation. Our group will be presenting on 4 issues, namely divorce, guardianship and custody, cause of action, and promise to marry. The first issue needed to be addressed is whether Malaysian courts have jurisdiction over this matter, as the issue involves Cindy, a local citizen from Malaysia, and Danny, who is a Korean. Cross-boundary marriage where the husband is not a Malaysian domicile, Malaysian wife has no right to make any application to the Malaysian court for non-Muslim cases. Under Section 48, subsection 1 of the LRA, it states that the Malaysian court only has jurisdiction to make a decree of dissolution of marriage if only both the conditions under these sections are satisfied before the court may proceed to hear the petition. This includes the domicile of origin and the domicile of choices of the husband. This position that upon marriage a wife acquires a domicile of dependence was affirmed in the case of Chanli and Chanli and Betty 1960, where it was held that the domicile of a married woman is that of a husband, while the marriage subsists even though the parties may be living apart. Therefore, Cindy's domicile depends on Danny's current domicile. It is stated in Mark and Mark 2005 that domicile of choice is not a question of law but fact. There must be an coexistence of the objective test of residence factum and subjective test of intention animus. There must be even very little more than physical existence of a person is to establish residence. For example, in the case of RIC and Duchess of Portland 1982, Justice North confirmed that residence in a country for the purposes of the law of domicile is physical presence in that country as an inhabitant of it. As for intention, the court will look into the nature of the contingency. If it is clear and foreseen, then the person will not get the domicile of choice, as it does not show any intention to settle permanently or indefinitely as decided in the case of RIC and Bullock 1976. To decide whether Danny has obtained a domicile of choice in Malaysia, these two prerequisites must be fulfilled in order to prove domicile of choice. It is likely that Danny fulfilled the test of residence factum as he resided in Malaysia for 6 years. Although it was due to work commitment initially, but then his plan to stay was because he married Cindy and created his family in Malaysia. As for intention, there is no clear or foreseen contingency that he will move back to Korea, and it can be said that he has the intention to reside permanently in Malaysia. Therefore, it can be said that Danny has obtained the domicile of choice in Malaysia. Interestingly, Section 49 of the LRA provides additional jurisdiction for the court to hear the wife's application, regardless of not having domicile in Malaysia, as long as the requirements stated therein are fulfilled. These provisions have been further discussed by the court in cases like Melvin Lee Campbell and Army Edward 1988 and also Jaya Sakti Kumarayanagam 1996. In these two cases, the court emphasized that at the time of the petition, if the petitioner is a wife, her husband's domicile is in Malaysia, or if she can bring herself within one of the statutory exceptions under Section 49 of the Act, then she can invoke the court's jurisdiction. On the facts, it can be observed Cindy has been residing in Malaysia the whole time, and therefore her application for proceedings can be heard by the local courts. Even if the current domicile of Danny fails to be Malaysia, it is clear that even if Danny's domicile of choice fails and his domicile of origin is revived, Section 49 still prevails, and the local courts still have jurisdiction to hear this case. The second issue is on whether there are any valid grounds to raise a divorce. To file a divorce, there must be first grounds to divorce. The first ground is dissolution of marriage by way of mutual consent. This ground is provided under Section 52 of the LRA, where they may present a joint petition to the court. This section is subject to Section 50, where no petition for divorce shall be presented before the expiration of 2 years from the date of marriage. But it is obvious that Cindy will not have a problem under this section, as she and Danny has been married for 5 years, which exceed the expiration date. However, this ground depends not only on Cindy but also on Danny's consent, because it is a joint petition, and therefore, if Danny does not agree to this divorce, this ground automatically fails. Fortunately, Section 53 allows for a divorce on ground of breakdown of marriage, where it refers to Section 54 on the proof of breakdown of marriage. Under Section 54, subsection 1b, it states that where the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent, it is a ground of divorce. The test here is the classic objective reasonable man test, where the judge put himself in the position of a petitioner and asked himself whether such a person with his personality and attributes can be reasonably be expected to live with the respondent in light of his conduct. The English case of O'Neill and O'Neill 1975 had decided that a subjective test is included as well, because in considering what the reasonableness, history of marriage, and what the petitioner and respondent have must be taken into account as well. An example of the application of this test is the case of Banu Sekaramani and Nagama 1991, where the court dismissed the petition because the husband wanted freedom and was bored of his wife, not because the marriage has irretrievably broken down. On the facts, it can be observed that Danny's act of abusing Cindy in this horrendous manner could not possibly expect her to live with him anymore. Since there are valid grounds on divorce open to Cindy, she must then satisfy the procedures thereof. She should first attempt reconciliation with Danny, provided under Section 55, a provision designed to encourage reconciliation where the court may order for, as can be seen in the case of P&S 2015. The High Court concluded that Section 106 of the LRA was constructed to provide platform for the marrying couple to restore their marriage and avoid hasty resort of ending the marriage. This provision is constructed to allow parties to have reconciliation except for the grounds on Section 51 and 52. Therefore, Cindy must attend the reconciliation session, because failure to do so may fail to obtain a decree of divorce as well. A decree nasi will be then issued to Cindy under Section 61. This means that during the 3 months period, Cindy and Danny are still husband and wife, but Cindy can apply to the court for a shorter period of the expiration date. In addition, the court may order Danny to pay maintenance to Cindy in light of Section 77b, and the assessment of maintenance is provided under Section 78 solely based on the degree of responsibility which the court apportions to each party for the breakdown of the marriage. The duration of the maintenance depends on Section 81, and under Section 82, if Cindy remarries, her right to maintenance is then ceased. In conclusion, Mary is entitled to divorce Danny, as the Malaysian court has jurisdiction to hear the case, and the grounds under the LRA is satisfied, provided she follow the procedures discussed earlier. Thank you.
My name is Rishima, and I'll be discussing guardianship and custody. A child is referred to a human below 18 years of age. Due to his or her minor age, the parents and the guardians are empowered to decide for them, as such persons are presumed to decide what is best for the children. However, in situations where the parents are lacking parental behavior or the parents have passed, the courts have jurisdiction to decide which party is entitled to the custody of the child. Malaysia, on one hand, is much concerned on the doctrine of welfare of the child rather than the best interest. The main statutes relating to the issue of custody and guardianship are as provided by Law Reform, Marriage and Divorce Act 1976 and Guardianship of Infant Act 1961. Also, the best interests of the child standards have been advocated and recognized in one of the articles of the United Nations Convention on the Rights of Child. This is clearly expressed in Article 3 of the UNCRC that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be the primary consideration. Section 88 sub 2 of the LRA, ranking in pari passu with Section 11 of GRA, provides that in deciding the custody of the child, the paramount consideration shall be the welfare of the child, and subject to this, the courts shall have regards to the wishes of the parents and the wishes of the child. Wishes of the parents most of the time will not be that significant unless it can be shown that those wishes are in line with the interests of the child. Now we will delve into the discussion of whether Mary could claim guardianship and custody for the children. Firstly, we will look at the 4 children that Mary has with Frank, each aged 5, 4, 2, and 10 months. Here, the application of Section 11 of GIA is discussed in Chen I Chu and Ngang Ngo Moy, where the court decided to hand the child back into the custody of the natural mother, as the court was of the view that it was in the best interest of the child. One of the reasons being, the court took into consideration the fact that the child is a female of tender age and that she will benefit from care and affection that will be afforded to her by her natural mother. Also, in the case of K. Shanta Kumari and Vijayan, the court said that in considering the paramount consideration, the care, comfort, attention, the well-being and happiness of the child are matters that should be taken into account. And in Tay Eung Kim and Yu Peng Seong, court was of the view that the maintenance of a stable and secure home in which the children can enjoy love and affection seemed to be the most important thing that should be taken into consideration in that case. Therefore, for Mary to get guardianship or custody for 4 of her kids, she would have to prove that they would have affection, comfort, stability, and a secured home in Australia, and that she has the ability to care for them. Moreover, under Section 88 sub 3 of LRA, there is a rebuttable presumption that it is good for the child below the age of 7 years to be with his or her mother. Since all Mary's children are below the age of 7, there is a high probability of her gaining custody of her children. However, it could be rebutted on the basis that she is moving to Australia for her doctorate. In Fu Kok Soon and Leonie Rosalina, the court initially ordered joint custody, but later changed with the consent of both parents, where the custody, care, and control were given to the father with unlimited access to the mother. The reasons for such variation were because the father refused to comply with the order that requires the children to be registered in a school in Perth, Australia, the place where the mother resides, because the parents live separately in 2 different countries. Similarly, Frank would have the upper hand here as his children already have a stable home here, and Mary would have to prove the stability she could provide in Australia. Also, again in the case of Chen I Chu, another reason the custody was granted to the mother was because the child had better access to her natural father who lives just across the causeway in Singapore. In contrast, the children would not have better access to Frank because he is living all the way in Malaysia while Mary would be living in Australia. Now, although 2 of Mary's children aged 5 and 4 were born illegitimate as they were conceived before Mary and Frank got married, unfortunately, an illegitimate child would have no ties with their father, and they shall be maintained by their mothers. However, here the issue of illegitimacy does not play a role as Mary and Frank got married, thus legitimizing both the children. On the other hand, Frank could be accused of committing adultery as he has a lover while still being married to Mary. Interestingly, in the case of Ko Cheng Mi and Lubin Chiu Pao Sing, the court held that adultery, although frowned upon by the Malaysian society by itself, is not a sufficient ground to disqualify the mother from having custody of her children. Thus, this does not give Mary any added advantage of claiming custody. In conclusion, Mary is highly likely not to receive guardianship and custody rights as there is no evidence of stability or even secure home or future for her children. However, she will be able to gain unlimited access to her children as in Fu Kok Soon. Now, when looking at Frank's 10-year-old child, LRA has made it a statutory requirement to consider the wishes of the child who is of an age to express an independent opinion. Section 88 sub 2 sub B of the LRA states that the court shall have regards to the wishes of the child where he or she is of an age to express an independent opinion. It is dangerous to assume that these living arrangements, though temporary, can be modified without any adverse consequences to the child. If the living arrangement, even temporary has been established for the duration of 1 or more years, it is generally expected that the status quo would be confirmed in the majority of defendant cases. Status quo here refers to the arrangements for the care and control of children, which apply at a particular point, usually the time at which a judgment has been delivered. In the case of Marina Nahulandran and Appia Nahulandran, the custody of one child was given to the petitioner's wife as the child was schooling in Taipei and appeared settled and happy in the circumstances. The custody of the other child was to be remained with the father as the child was settled, contented and happy with the father. The boy also seemed to have an emotional attachment with the woman whom the father is in a relationship with. Focus in this case was the children's happiness of being with which parent and not the dispute between both the parents. In the current question, Frank's 10-year-old child would be in primary school, which means relocating to Australia could have an adverse consequences on him as he would have been comfortable with his surrounding in regards to school or friends. However, the child could also have a say in this decision as per section 88 sub 2 sub B. And in Mahabir Prasad and Pushpa Mahabir Prasad, children aged 7.5 and 8.5 years respectively were given the opportunity to express their wishes. Similarly, Frank's 10-year-old son could be deemed to make his own decision under section 88 sub 2 sub B as mentioned earlier, if allowed by the courts. It is likely he would prefer to stay with his father due to the familiarity of the current circumstances. Therefore, Mary is very unlikely to get the custody of Frank's 10-year-old child. Finally, we will be looking at Mary and Zali's illegitimate child. In general, Islamic law imposes the responsibility of the father as the primary natural guardian of the minor. Thus, in the event of divorce and the custody of the child is given to the mother, the responsibility of the father being a guardian continues until the child attains the age of puberty or married in the case of a girl. LRA and GIA will not be applied here as Zali is a Muslim. Since Mary and Zila are not married, their child is considered to be an illegitimate child. Section 85 of the Islamic Family Law Act 1984, the custody of illegitimate children appertains exclusively to the mother and her relations. This is further in line with the issue of nasab under Islamic custom, where an illegitimate child has no relationship whatsoever with his or her biological father. With this, it can be said that Mary would get the custody as under Islamic law as mentioned. And in conclusion, Mary would only be able to get the custody of the illegitimate child with Zali, while Frank would get the custody of 5 other kids, including her former stepchild.
My name is Brandon, and I will be speaking on cause of action and breach of promise to marry. Zali and Zila may attempt to legitimize the child as their own to prevent Mary from claiming custody by registering the adoption of the child. Under Section 6 of the Registration of Adoptions Act 1952, where any child under 18 that has never been married is in custody of and is being brought up, maintained, and educated by 2 spouses jointly as his or her own child under de facto adoption for a period of not less than 2 years, such persons may produce evidence, either oral or documentary, to satisfy the registrar. The couple's child are under de facto adoption here, as they have been in the care and control of the couple for 5 years, taking in the child as their own due to their inability to have one. The child is also under 18 and has never been married. As such, they may therefore show oral and documentary evidence as proof of their de facto adoption. If the registrar is satisfied in all circumstances of the case, it is just and equitable for the welfare of the child and the fees are paid, the registrar shall register an adoption for the child Zali and Zila took in as their own. Additionally, under Section 10, subsection 2 of the RAA, the registrar shall not register any adoption unless one of the persons adopting is the mother or father of the child and at least be 25 years old and 18 years older than the child. Zali is the father of the child in question and is likely older than 25 years old due to his status as Mary's boss, who is currently 27 years old, and similarly must be 18 years older as the child is only currently 5 years old. As such, the couple may register their child for adoption, giving them official custody. However, Aziza stated in his journal that registering a de facto adoption does not confer parental status to the couple, and the court may therefore refer back to Section 85 of the Islamic Family Law Act, which gives exclusive custody to Mary as she is still the rightful mother of the illegitimate child. However, they may argue under Section 82 that Mary is not a Muslim and therefore does not have a right to custody. If the courts think that the best right of custody lies with the couple, Zali and Zila may therefore be able to enforce their claim in having a custody for their child. Alternatively, if the court orders for custody for Mary, Zali and Zila may claim for the custodial order to be subjected to conditions under Section 87 of the Islamic Family Law Act. Subsection 2E provides that a child may be prohibited from being taken out of Malaysia. Zali and Zila may henceforth argue that their child's upbringing has necessarily been fostered in Malaysia, and Mary's plan to move to Australia would disrupt the child's well-being and development. Therefore, Mary will not be able to bring the child to Australia as long as the courts consider that the welfare of the child is significantly linked to his upbringing within Malaysia, possibly leading to a more suitable arrangement for Zali and Zila to continue caring for their child. The next issue is between Joseph and Olivia. Firstly, there is a valid promise to marry between them. In the case of Doris Rodriguez and Bella Krishnan, it was stated that the Contracts Act 1950 covers a promise to marry, and thus the requirements are similar: an offer, acceptance, and consideration. Furthermore, in K. Murugesu and Nadaraja, affirming the case of Harrison and Cage, consideration may come in the form of mutual promises, and each party may have an action against the other for non-performance. The fact that Joseph had gotten engaged to Olivia shows that there is a valid offer and acceptance, whereas the consideration comes from their reciprocal promises to marry each other. There is therefore a valid promise to marry, which Joseph breached by refusing to perform his engagement of marrying Olivia. As such, Olivia is entitled to damages, that is, general and special damages. Under general damages, the case of Dennis and Senya stated that the injury to the affections of the plaintiff, the prejudice to his or her future life and prospects of marriage, the rank and condition of the parties, and the defendant's means must all be taken into consideration in assessing damages, whereas Tanalashmi and Sundaraju expands it to include personal feelings and pride, such as hurt, humiliation, and anguish. In addition, the courts may impose exemplary damages if they find the defendant's conduct to be aggravating enough for punishment and deterrence purposes. In this situation, Olivia clearly has a great desire to marry Joseph, to the point of refusing to tell him of her condition because she believes that he wouldn't mind, and even bought a wedding dress in anticipation. As such, the rejection left her heartbroken and humiliated once realizing that Joseph will leave her due to a barren condition. This may also cause herself or her peers to think less of her due to a failure to marry or inability to give birth, lowering her self-esteem and prejudicing her prospects of future relationships. The courts will therefore account for all of these hurt feelings and possibly accrue exemplary damages if they feel it to be reasonable. However, as Joseph did not do anything to aggravate his breach, merely calling off the engagement because he was reasonably shocked to learn of Olivia's inability to have children, the courts are unlikely to accrue any exemplary damages for Joseph. On the other hand, Olivia's claim for special damages will relate to damage specifically claimed for monetary loss. In Finlay and Cherney, it was held that where circumstances existed at the time of contract to marry, and both parties reasonably contemplated that a breach must affect the property of each other, there is an action for special damages. This can be illustrated in the aforementioned Tanalashmi case. The plaintiff had claimed for money spent to fund an engagement ceremony and wedding accessories. In addition, Dennis and Senya shows that the plaintiff may claim for damages incurred to third parties. Here, the food for the wedding ceremony was paid for by the father and the brother of the plaintiff, which accrued into special damages. Similarly here, Olivia's expenses on the wedding dress and her parents' deposit on the wedding dinner must have been contemplated to be affected by Joseph's breach of his promise to marry, as they are par for any wedding ceremony. Therefore, she can claim special damages for a dress and the amount of the deposit paid for the wedding dinner. In facing these charges, Joseph may invoke a few defenses to his benefit. These come under Section 3 of the Civil Law Act, where courts may apply English common law as administered before April 1956. The first defense is that a contract to marry is not a contract uberime fide. Under Beachy and Brown, the general rule is that parties under promises to marry do not have to disclose to their partner all relevant facts and information. Here, the plaintiff was engaged to another party when the promise was made, but did not have to disclose it to the defendant. Justice Cockburn expresses that the exception is if the information touches on the root of the promise to marry, with Justice Crompton stating this to include incompetency to perform matrimonial obligations. In such cases, by excess and necessity, the promise may be refused. Manson further states in his journal, if the man finds the woman quite different from what he had reason to think her after the promise, he may refuse it. Similarly here, Joseph wants children with Olivia, even telling her that he wants 10 of them, showing how much weight he places on expectations toward childbirth. His expression of this desire was never declined by Olivia, with her refusing to tell him otherwise. He only realized that Olivia was barren after the engagement, once told by her parents. These can therefore be considered crucial matrimonial obligations which directly touches on Joseph's root of marriage, and is considered necessary information to be disclosed, even if typically a contract to marry is not a contract uberme fide. Joseph is therefore justified to refuse the promise to marry, as Olivia should have disclosed her inability to have children to him. Alternatively, Joseph may invoke Olivia's physical and mental infirmity as a defense. Under the rule of Jefferson and Pascal, where there's any mental or physical infirmity rendering the plaintiff unfit for marriage that comes into the knowledge of the party after the promise, it justifies a refusal to marry. Here it was alleged that the plaintiff suffered from tuberculosis. However, since the plaintiff was declared healthy and the defendant still refused marriage, the defense failed. Furthermore, physical infirmity is confirmed to include impotency. In Hall and Wright, the obiter dicta and dissenting judgments decided that cases of impotency are sufficient as physical incapacity to refuse marriage. As such, Olivia's inability to get pregnant is considered an infirmity because it parallels the incapacity to perform marital obligations of having children, and Joseph's realization by her parents only after the promise was made makes him legally entitled to refuse the promise. On the other hand, mental infirmity may be elaborated under Section 51 of the Mental Health Act, where a mentally disordered person means any person in due course of law found to be mentally disordered and incapable of managing himself and his affairs. Joseph may argue that Olivia's act of not notifying Joseph of her inability to have children is proof of delusion incurred by trauma due to her accident when she was 10 years old, even when he specifically told her his desire for having 10 children. Her unreasonable rationale that he would not have minded may evidence her incapability to perceive matters related to her own engagement. If Joseph can prove under Section 51 of the Mental Health Act that she is incapable of managing her own affairs or should be mentally disordered by law, this may be sufficient to establish her mental infirmity. As a result, Joseph is likely to be found not liable for his breach of promise to marry.